Hands on the hood. Anything you don't need that's gonna poke prod me? Pat you down for officer safety.
No.
Hands on the hood.
That's not a pat down. That is pull my bra.
It is definitely a pat down. We can argue all you want. I don't know why you are being so defensive.
You are not patting me down. You are feeling up under my bra.
Is that... I'm allowed to.
The deputy claims that she is allowed to feel under the driver's bra as part of the pat-down, and the driver protests. During a Terry or traffic stop, law enforcement officers are generally allowed to perform a limited pat-down search of a person for weapons if they have reasonable suspicion that the person may be armed and dangerous. As the Supreme Court explained in the 1993 case of Minnesota versus Dickerson, quote, "The purpose of this limited search is not to discover evidence of crime, but to allow the officer to pursue his investigation without fear of violence. A protective search must be strictly limited to that which is necessary for the discovery of weapons which might be used to harm the officer or others nearby. If the protective search goes beyond what is necessary to determine if the suspect is armed, it is no longer valid under Terry, and its fruits will be suppressed. Accordingly, even assuming that the officer had reasonable suspicion for the initial traffic stop, which she did not, and that she had a reasonable belief that the driver was armed, which is questionable, a court would likely conclude that the scope of the pat-down exceeded the permissible scope of a Terry stop and frisk. While an officer conducting a lawful pat-down may pat the exterior of clothing near the bra, a court would likely find that the deputy's decision to feel under the bra in this case was more invasive than permitted by Terry, as the level of intrusion appeared to be aimed more at discovering evidence of... After talking to the DA, the deputy allowed the driver to leave without further incident. Very little information is available about this encounter, and it's unknown if the driver filed a complaint or intends to pursue legal action. Overall, the deputy gets an F for maintaining a rude and unprofessional demeanor throughout the encounter, demonstrating a fundamental misunderstanding of both Texas traffic laws and the Constitution, and repeatedly violating the driver's Fourth Amendment rights. While the Supreme Court has upheld the constitutionality of traffic stops based on so-called reasonable mistakes of law, in this instance, the statute explicitly stated that it did not apply to bike racks, showing that the deputy was simply ignorant of the provisions of the statute that she was attempting to enforce. When the driver attempted to correct her understanding of the law, the deputy responded in a condescending and defiant manner, despite repeatedly being incorrect in her assertions. And while the deputy at least did not attempt to pursue interfering charges against the driver, she also did not apologize for or even appear remotely remorseful about unlawfully detaining her, searching her, and threatening her with arrest. This encounter underscores the critical importance of officers thoroughly understanding the laws they enforce, and highlights how a single misinterpretation of a statute can escalate into multiple constitutional violations.